Yes.
My lord, I cannot keep him, my lord.
Yes.
Now, today itself,
Uh-huh.
I find the Bhaktana.
Okay.
Yes,
You are,
yes, that's point number 1.
you are for respondent number 1.
Yes.
Okay.
So, this matter, that I will fix on 25 November.
Who is for the petitioner? Have you taken consent?
Yes, ma'am.
Okay. You are Mr.
I'm in Viren.
N. Viren, learned counsel for the respondent number
1.
1. Huh?
Already I had
Submits that he has entered appearance on behalf of respondent number 1 and therefore on today itself.
Yes.
Today itself, and therefore he requires some time. Prayer is allowed accordingly. Release this matter on
25 November.
25th November is a holiday.
Monday.
Holiday.
25 Monday.
It's a holiday.
Sorry, we are coming from Manipur.
That's right.
So the schedule is not ever now. Uh, 29 November.
29th of November.
Friday.
Yes.
Huh? Which phone number?
Yes, next. Lordship, may I beg to mention item number 25. I'm mentioning on behalf of P.D. Balita, the abortive advocate. This matter, item number 25, is on the hearing list. This may be posted on 29. I'm informed that he can come on 29th of this month. This month. Ninth will be a difficult proposition. Everybody will leave on 38th. Yeah. All my private secretaries. Any other day. On after 3 weeks. After 3 weeks. 29th will be difficult. Yes. 38th, everybody is living here. Except me. Yes.
May it please your lordship. Your lordship, I would like to mention item number 24, your lordship, which is a supplementary hearing list. This appeal matter has been, your lordship, pursued by my sister T. Jine, your lordship.
Okay.
Recently, so she lost his uncle. For that, she went back to her hometown. So this matter may be listed after 2 weeks, your lordship.
Okay. It is submitted that the conducting additional public prosecutor,
Yes.
MST is in bereavement. Accordingly, a prayer for adjournment is made. Prayer stands allowed. List this matter after
2 weeks, your lordship.
after.
Deeply obliged, your lordship.
Lordship, I beg to mention item number 3. I may be kindly allowed to withdraw this petition since my associate has made some error while filing
With
the petition.
liberty.
Yes.
Okay. It is submitted by the learned counsel for the petitioner that he may be allowed to withdraw the present petition, criminal petition, and to file it afresh after curing the defects. Prayer is allowed. Accordingly, writ petition stands closed on withdrawal with a liberty as prayed for.
Deeply.
May I, lordship, please. Lordship, I beg to mention item number 23 on behalf of 23. On behalf of Arakat. Kindly, this matter may be fixed on 12th November.
10th November.
Yes, lordship.
May I, lordship? Lordship, I would like to mention item number 5 here.
Item number
5. My lord, matter may be listed after 3 weeks due to main counsel B. Arun has suffering from viral fever, so he won't be able to.
hello. On the prayer of the petition. After
3 weeks.
3 weeks.
May I, my lord? My lord, I may be allowed to mention item number 6.
Yes.
We are for the petitioner hearing, my lord.
Have you
this
taken
matter-
consent from the other side?
Yes, my lord.
When?
Matter
So
may
I'm
be-
the other side, your lordship. And the other side, in fact, your lordship, it's a, they have, this is a petition where they are praying for quashing on the basis of the settlement, but other side has not been jointly come as a petitioner. So they have made as a private respondent here.
Now, have they filed any affidavit?
No, your lordship.
They have also not filed.
They have been made as a private respondent.
So
Your
they
lordship.
have, I think, entered appearance.
Yes, they have entered appearance, your lordship.
Did they file any affidavit saying that, yes, we have compromised?
No, no, no.
Then we'll adjourn it.
Yes, your lordship.
Yes.
Fixed on 28, madam.
20,
28 of this month.
28.
Yes, madam.
But what will happen? Where is your counterpart? Have you taken consent?
Yes, madam.
Until and unless they file an affidavit and
Yes.
says that, yes, there was a compromise, how can you decide? Okay, 20. We'll see on that day.
Yes, your lordship.
But
Deeply-
not on verbal concession.
Yes.
We need an affidavit.
Yes, your lordship.
Yes.
Obliged.
My lords, I on behalf of Tagum Jabo, conducting counsel of this matter, and he is out of station.
Item number?
I beg to mention item number 4. Matter may be listed after 3 weeks. I have taken consent other side of.
After 3 weeks. On the
Thank you.
prayer of the land.
Item number 4.
Right, please, Lordship.
Hmm.
Lordship, I beg to mention item number 8.
Item number?
8.
Yes.
The leading counsel T Tang is out of station.
Have
Kindly,
you taken consent?
yes, Lordship.
When?
Lordship, kindly fix the matter for tomorrow, Lordship.
Tomorrow, not tomorrow. We'll fix it on tomorrow is 23. We'll fix it on Thursday. Okay, 24th.
Item number Lordship 8, Lordship. Lordship, there is some
Therefore,
which affect Lordship.
so therefore we'll take in day after tomorrow, not
Yes,
tomorrow.
okay, Lordship. Day after tomorrow, Lordship.
Yeah.
Obliged.
Lordship,
Yes.
Lordship, I have an instruction from my client to withdraw the case, Lordship.
Who are you? What is your name?
Lordship, SKSN Mohammed, Lordship.
SKS and Mohammed.
Yes, yes.
Learned counsel for the petitioner submits that he has instruction to withdraw this application. Accordingly, same stands closed on
With
withdrawal.
liberty, Lordship.
What liberty?
To file again, Lordship.
Huh?
Lordship, if necessary, to
Okay.
oblige, Lordship.
The learned additional public prosecutor has objected to such prayer report claim. Yes. Yes.
Lordship, this is an anticipatory bail application.
What is the affair?
FIR is page number 12, annexure 1. This FIR says, Lordship, may I read the contents, Lordship? It is to inform you that on dated 5/10/2024 at around 1500 hours, when I was on my way to pick up my son from his tuition class, suddenly a car arrived and stopped near me, and one Sri Tangnai
What
one.
kind of affair is this? Okay, city intent. Doubtful.
This is my auntie, younger sister of my, there was a,
CD interim appear before the IO. CD when?
Lordship. It is Tira Lordship. So one week, Lordship.
Give a date. Generally, in case that we should fix a date. Give a date as per your convenience.
29 Lordship.
Huh?
29.
29th of this
No,
month.
30 Lordship, 30th of this one.
30th.
Lordship interim order may be.
Interim. order, that's- But you within 13 you
Yes,
appear before the IO and record your
I will
statement.
come back.
Apply.
We'll do one thing, not 38, 38 of
October month, right?
October. Okay, 30.
30th of-
Yes. Yes,
I put a petition on my.
yes. We know you are for a petitioner. Now tell us.
Your respondent 2 is not appearing. I'm putting respondent number 1.
Service is complete.
Yes.
Yes, ma'am.
Yes. Now what is to be done?
My lordship, conducting counsel is out of station, so my lord.
Tell that only this matter was left. So that's why Mr. Tara from yesterday, I have stopped reading files. Unnecessary wastage of
Yes.
time, isn't it?
Yes, my lordship.
Why should we read twice? Yes. So I have just how it was sent, it has returned back in that way.
J Modi. After 4 weeks.
After 4 days. Yes, what is this?
My lords, I appear on behalf of respondent number 2, the complainant.
Hmm.
I'd like to.
Lordship, I am for petitioner.
Hmm.
Lordship, actually, this is application under section 528 of BNSS for quashing the FIR. And Lordship, actually, both the petitioner and respondents are businessmen in this case and doing business of kitchen steel equipments. There is a business transaction between the two.
Where is the affair? Where is the affair?
Please, Lordship, page number 13 of my petition, Lordship.
Page number
13, 1-3.
any type copy? How do you read this?
Lordship, page number 15, this is a type copy. Page number 15, 1-5. May I read?
Just a minute. So why should we cause this?
Lords, I appear on behalf of R2. I just want to make some humble submission.
We will hear you listen. Why should we cause this affair?
Lordship, actually, in this matter, both the petitioner and respondents are businessmen. They are doing the business of steel kitchen equipments, and they are in business since 2019.
Where is additional people? Yes.
And Lordship,
Any
actually,
case there is here? Case there is here?
G. Tador, Lordship, additional people, he is appearing this case, Lordship. He is just coming, Lordship. The brief is with him, Lordship.
This is
Lordship.
Lordship, this is the civil nature case, and Lordship, I want to mention on 25th of September, the Honorable Bench of Shri Justice Cardiac ET agreed that this is a civil nature case, and
I am not agreeing with that.
okay, and they have
listen to me. When it is absolutely civil nature, of course we can quash a petition. It is in a very initial stage of an FIR. A specific statement is made that you are not the owner, you have cheated. So prima facie case is made out. Why should we interfere at this stage? That's all.
Lordship, I am owner of the firm. I have my office.
We
Lordship,
will not go into all those factual aspects in a quashing petition.
May I, my lords?
That's precisely, my lords, from the very beginning.
You take your seat, please. When we are interacting, which is in your favor, why should you argue? Yes, where is the public prosecutor? Yes, there is there. Yes. Yes, argue.
Lordship,
Yes, proceed.
actually, on transaction between the both on 14th May 2024, respondent number 2 approached the petitioner for ordering the commercial kitchen equipments. Petitioner prepared the quotation of the said ordered item and the said quotation was agreed by respondent number 2 and sum of rupees 4,50,000 paid to the petitioner admitted. And on 30th May, respondent verified their order item and made balance payment of rupees 4,50,000 to the petitioner. This is also admitted and total 9 lakh rupees I received. And assured that he will pick the items within a week. Petitioner repeatedly and petitioner prepared the item and repeatedly requested the respondent number 2 to pick the items because the items occupied the space that was rented space for me, and respondent number 2 refused to pick up the items because his order was with next party was cancelled. I was ready to deliver the item. I am today also ready to deliver the item. I have no criminal intention, like my lordship. I have no fraud committed by me, lordship. I have a permanent business place. I am a trader, lordship, and this is not my first transaction with the respondent number 2. He is doing business with me since 2019. Lordship, I am still ready to deliver the goods.
Yes, yes.
I have
What
no-
do you say? Just a minute. What do you say? He's willing to give you.
My lord, sir, if you may refer the WhatsApp communication which we have submitted to the police, we have been chasing them right from the beginning.
No,
and
the learned counsel is making a statement that
my
he
lords,
is
they have
giving-
not submitted any iota of evidence to that effect. We have the e-way bills. They are saying that we have
So
cancelled.
he's making a statement. I will record it and adjourn it till the next day.
My lord, now,
If you agree.
no, my lords, the thing is,
I'm
we have
ready.
now already, we have already made the purchase from a different vendor now. post after he refused or he was unable
So
to
return
deliver.
the money.
Okay, Lordship, I am ready to return the money also, but Lordship, I request before the Honorable Court, first I have to sell the ready prepared item to the market. Kindly grant me reasonable time, or so that I can first sell the goods item to the market, and then I will return. I am ready to return, Lordship. I have no grievance.
According to you, how much time will it require?
Lordship, at least 2 months I required, Lordship, because these items are heavy items and measurement, these are prepared by measurement. I have to find a customer in the market and sell, and then I will return. I'm ready.
Any bail application filed by you?
No, Lordship. I have joined the investigation, Lordship, by the direction of Honorable Court on 29th of September. I also joined the investigation at Naharlung Police Station. I am fully cooperated, Lordship. But
have you cooperated? But yeah. When have you appeared? When have you appeared before the IO?
29th of September, Lordship, by the direction of Honorable Court, Lordship. 29th of September, Lordship. I have filed my affidavit before the Honorable Court regarding my appearance and
29th of
September, Lordship.
Yes, what do you say about that?
As per IO, this petitioner is not cooperating with.
Whether he has appeared or not before before you.
He appeared, but
what cooperation? Have you recorded his statement? What do you mean cooperation?
Cooperation means he just try to conceal the thing that
That's a different issue. See, police cannot say that you will have to say whatever I want. If he has appeared, he is willing to record his statement. First, record his statement. Did you record his statement?
For further investigations, we have issued.
Please answer my question. Whether the IO has recorded his statement.
Yes, Lordship. Yes, Lordship. I have given my written.
According to him, he has given statement. According to you, he has not cooperated. Where is his statement? Have instruction. Where is the which order?
Yes, Lordship.
This is a clear case of cheating.
When
so further investigation is required, Your Lordship, to ascertain the fact whether fraud was committed or not.
Lordship, on 29th, I have given written statement to the IO, and I came from Delhi. Lordship, petitioner is resident of Kundli, Sonipat, Haryana, Lordship. And the police station Naharlung is almost 2,500 kilometers far away from him. And he came from there to attend.
Which, according to you, pursuant to which order you have appeared before the IO? Tell us.
Yes, order of 25th, Lordship. Order of 25th, Justice Cardiac ET directed me to appear on 29th. Order 25th September, Lordship.
25th September.
Yes, Lordship. I have given undertaking before the Honorable Court.
You will appear in section 29(9).
Yes, Lordship. Lordship, I have filed my affidavit of appearance and with proof, Lordship, my tickets, my photographs, all before the Honorable Court, Lordship. I have filed my affidavit also, Lordship. But IO did not cooperate me, Lordship, and ready not ready to mark my appearance also, Lordship. I have called to SP also, Lordship, and mentioned before the SP Sahab that
File an affidavit.
I have filed, Lordship.
File
I
an
have filed.
affidavit.
I have already
Where is
filed,
that?
Lordship. I have already filed on 30th September. 30th September, Lordship. With proof, Lordship. With proof of my appearance, Lordship. My tickets, air ticket.
My lords, as per the investigating authorities, what we were informed, that he appeared on 29, but he was further directed to appear on 3rd for his
Oh,
statement to
we are not interested with you. This is a criminal investigation.
Yes, sir.
We'll see on the whether any prima facie case is made out
Yes.
or not. This is the primary thing.
Yes, my lords.
The last but one paragraph shows that you have specifically alleged cheating. Okay, fine. But these are admittedly offenses arising out of financial transaction. These can be compounded. Listen to me. This can be compounded. He is making a statement that I'm willing to refund, give the amount or give the materials which you are not agreeing. Okay?
My lords, just one thing.
No,
my lords.
I will hear you.
Okay, my lords.
You are not agreeing. So therefore, in that regard, he is also arguing that you are having a long-standing business transaction.
No, my lords, no.
Listen, we cannot decide all these factual aspects in a 482 petition.
Yes, my lords.
Isn't it?
Yes, my lords.
So therefore, in that background, this court has said you can appear. He had entered appearance. We want to see what materials he has produced.
My lords, also the lordship on that day also directed them. So they submitted that the goods are ready. So my lords directed them, okay, bring the goods along with you.
See,
they are complying as
in
per whims
the-
and caprice
in
of their.
482 or whatever in the BNSS, on admitted documents, even facts can be entertained under 482 or in a revisional power. There is no quarrel now. So therefore, without taking a hurried decision, we want to know what is the stand of the IO, and you are jumping on it as if you are deciding everything. Please take your seat. That's why I'm asking you to take your seat. You are the third party. We are just, what is the stage of investigation?
My lords, may directly IO to appear and present it before your lordship for them.
We will do what, we know what is to be done.
Investigation is not proceeding further because of non-appearance, non-cooperation of the petitioner.
Have you filed any reply? We'll make this IO responsible. Only saying that he is not cooperating will not do. He had filed an affidavit saying that this is my ticket, I appeared, I recorded my statement. Then what is your stand? Give back the case diary, and we are fixing it next week.
Your Worship, main thing is that ingredients of cheating is clearly established in this case. Prima facie it is there, and amount was received by the petitioner was not disputed. Amount already received.
Amount not disputed. It's a financial transaction.
Yes.
It's a civil nature.
And
why the criminal
and when
is
there
allowed to be?
And when there
You can dictate the judgment either way right now.
And when there is criminal case,
Fine line. There is a fine line.
when there is a criminal case registered against under 420 or 318 of BNS, it's one Supreme Court, Appeals Court, Honorable Appeals Court judgment is squarely covered in this case. Commercial transactions regarding pertaining to the 420. In investigation, so it cannot be called. It cannot be.
We are not staying in investigation.
And
Who has stayed in investigation? Not yet. No investigation is stayed till now.
And
Niharika. We are relying on Niharika judgment.
Niharika as well as.
Problem is this: you people are only to the judgments.
Rajesh Bajaj.
I can give you 100 judgment this side, 100 judgment that side. A civil dispute cannot be couched with the color of criminal thing. Only writing a line will not do. And at the same time, we'll say that all civil matters will not be, cannot be said that there is no criminality.
This judgment is pertaining to the specific is clearly covered in this case pertaining to the commercial transactions. Generally, 420 arises.
You want me to dictate this judgment right now? Allowing this.
No, I'm just appraising.
Dealing with this judgment.
I'm appraising this court, yourself.
Dealing with this judgment. See, you are going somewhere else. We want to know who pass an appropriate judgment. We are not taking view of any and not taking anybody's side. We want to do justice. If there is any intention of sitting, any materials is there, of course. Coupled with the statement in the last but one paragraph, we can ask him, we can dismiss this petition. Or if there are material collected, if he can produce, showing that this is the situation, this is absolutely a civil nature, we can very well do the things. And your investigating officer, except saying and having some WhatsApp messages, nothing is there. Have you visited, is your investigating officer visited his place? His allegation is that there is no office in the name. Anything you have collected? He says, yes, they can stand that, no, I have my office, this is my address, all these are. Now?
Prior to 25 September order, there were more than
Lordship,
7 notices
Lordship,
were
may I
sent
mention?
under Section 35 of BNSS. So even telephonically he was asked to appear before the IO.
You can, under BNSS, you can record his statement through virtual mode.
But he's not even responding.
Arguing? Mr. Counsel, from where are you arguing all this? File an affidavit by the IO saying that no, all these are incorrect. He has not appeared before me. These are false. So from where are you arguing that he is not cooperated? He on oath has filed everything that I appeared on such and such that before IO, so and so on and so forth. That is on oath and your is on verbal. Which one should be believed?
As per
about Supreme Court judgment.
As per CD, I'm submitting as per CD.
Your CD, what your CD?
Record.
Not cooperating. Is the CD said he appeared on that day, but he has not answered, he has no, nothing is there. Even there is no reflection that he has appeared on 29/9 in your CD. Is it the way to investigate? Show me from your case diary that IO has written that on such and such that he has appeared. But however, he has not answered, he has not cooperated. Tell us, what is to be cooperated here? What do you mean by cooperation? He has appeared before you. Ask him question, whatever you cannot force him to give an answer as per your wish. Ask him question, he will answer. Or he will produce documents, we will see it.
Then you're also
That is what I am saying from when I started taking this brief. And you are going to Supreme Court judgment.
actually it's covered because it's under investigations.
See, judgments, Supreme Court judgments or any judgments are required when we are finally deciding this matter. And to finally decide, we must have some material. Admittedly, in the first part of the FIR, it apparently seems that it is a commercial transaction between two parties. From that angle, it may be a civil in nature. From that angle. However, at the penultimate paragraph, he has specifically stated that yes, I was not even aware that he is not owner of those villages. I have went here. So it initially says that there is an initial deception in his mind. Moment there is an initial deception, 420 prima facie come, investigation will say, he will appear, investigation will carry on. That is the issue. But he is cooperating at the same time as per his affidavit. He is making a statement that this is a business transaction, I am willing to do so on and so forth. In that backdrop, investigations, his statement is necessary.
Yes, your lordship is I agree with your lordship, but your lordship, is this case?
You are a very important and responsible officer of court. Additional public prosecutor and public prosecutors are not appointees of the state,
Exactly, yes.
nor they are representative of the IO. Public prosecutor and additional public prosecutors are appointed in consultation with the High Court.
Exactly, your lordship.
You are here to assist, not to look into the matter through the eyes of the IO. Okay? And our responsibility is to do justice, complete justice. So in that context, advise your IO to give
Lordship,
this kind
may I mention?
not to give this kind of status report. If he gives it, let him also say the correct fact that he appeared and he did not cooperate. He appeared in such and such that, and why he did, why according to the IO he is not cooperating. And under BNSS you need not bring a person here.
Yes, Lordship.
Yes, it's a,
You have, that's why we are approaching in the modern days. Evidence can be taken through virtual mode. Okay.
yes, your lordship. Yes, then if petitioner is ready to repay back the amount taken,
Heard the learned counsel for the parties. The present petition is filed under section, what is that provision? BNSS. Under section 528 of BNSS 2023, seeking quashing of FIR number 74/2024, registered under section 420 IPC at Naharlagun Police Station. The fundamental ground of challenge made by the petitioner is that a bare perusal of the FIR discloses that the dispute, in fact, is a dispute which is civil in nature and arises out of a business transaction between the petitioner and informant. On the other hand, it is the case of the informant that a reading of the affair, more particularly the penultimate paragraph, prima facie discloses that the petitioner had committed an offense under section 442 IPC, and therefore this court should not entertain such a petition. Pursuant to this court's earlier order, the learned additional public prosecutor has produced a case diary, or what is this?
case diary.
Is it a case diary? Is it a case diary?
Because there was no investigation was not
So don't say this is a case diary.
status report.
What status report? Case diary means you'll have to start that I have entered this diary, this FIR is received,
Exactly.
this is DD entry, then I have proceeded this, so and so has appeared, nothing is there. However, in the considered opinion of this court, except submitting certain Xerox copies of WhatsApp messages between the parties, nothing is available in the case diary. Nothing is available in the case diary, including when the GD entry was made, how the investigation started. At the same time, it is the stand of the petitioner that the petitioner had appeared before the concerned IO on 29/9/2024.
Right, sir.
Is that it? Is that it?
Yes,
29
and recorded my statements.
29/9/2024 and got his statement recorded. In support, the petitioner has also filed an affidavit enclosing the boarding passes, etc. However, except stating in a forwarding letter by the IO that the petitioner is not cooperating, even after issuance of notice, though it is recorded that though the petitioner has appeared but not cooperated in the investigation, and a notice was issued on 3/10/2024. First, it is also not discernible why the IO has recorded that the petitioner has not cooperated. Be that as it may, in view of the stand of the petitioner, this court is of the view that before proceeding further in this matter, the statement of the accused be recorded by the IO along with any materials in support of the along with any materials that may be produced by the petitioner accused. Accordingly, the matter stands adjourned and be listed on
after 10 days.
we are fixing it on fourth of November.
Not one humble request. We not be kindly direct the IO to be present on the next date for better
No, we are
assistance.
not. IO is having many other works, not only your case.
Right now.
Will until and unless it's very important, we will not call the officers. He is having not dealing with only your case. Calling him for 2 hours is a interference with the administrative work. What you have written? In the meantime, the IO may record the statement of the petitioner once again as provided under BNSS 2023,
Yes.
including by digital/virtual mode. The petitioner shall cooperate with the IO and file an affidavit thereafter.
Right, sir.
Case diary is returned back, the IO shall produce the case diary on the next date, incorporating the important materials and the extra and including the physical case diary, not this kind of things. This is not the case diary.
Right, sir. Oblige, sir.
And in the meantime, if possible, come back and say that
Right, sir.
we have settled. Yes.
Oblige, sir.
Yes, what is this?
Please, Your Lordship, is it an application under section 483 of BNSS 23 arising out of Duimuk Police Station case number 71 of 2024?
No, Your Lordship, it's a bail application.
Bail application.
Your Lordship,
Where is the affair?
Yes, Your Lordship, in the meantime, charge sheet has been filed, Your Lordship. Oh. So after charge sheet, they have not approached the trial court, Your Lordship.
Heard. Swenso. This is an application under section
483 BNSS
of BNSS by the applicant Srimati Nuresa Khatun, praying for grant of bail to her accused grandson, who was arrested by Doimuk police on 15/7/2024 in connection with
Duimuk PS case number
Doimuk PS case number
71 of 2024.
71 of 2024 under section
179 BNS.
179 BN
3 bracket. Oh, this is case number, yes, Your Lordship. 179. Yes, BNS, Your Lordship.
Okay,
That is
put-
for
It is submitted by the learned additional public prosecutor that investigation has in the meantime been completed and a charge sheet has already been filed. On being charge sheet number,
Your Lordship, charge sheet number, Your Lordship, it's Yes, Doimuk PS charge sheet number 43 of 24.
43 of Tuimuk Police Station Search Sheet number 43 of 2024.
Under section
Under section
179/3 bracket clause or 3 subsection 5 subclause 5 of BNS.
3 within bracket 5
Yes,
BNS.
BNS is dated 26/9/24.
Dated 26/9/2024.
Yes.
In view of the aforesaid, the present bail application stands closed with a liberty to the petitioner to approach the learned trial court below seeking regular bail, and in the event such application is filed, same be considered as per law.
Deeply obliged, Your Lordship.
Keep these two matters in earlier petition. Close. Yes, anticipatory.
Yes.
Huh?
So in this case, on the earlier occasion, this interim order was granted, but this petitioner has been arrested in connection with another case. So he could not report it to IO. So time may be given.
So you will have to file an.
I'm not filing anything. When I am released on bail in another case, today case is this at the judicial magistrate first class.
We'll adjourn it today.
Yes.
Okay.
Maybe adjourn.
On the prayer of the learned counsel for the parties, list this matter when
After 3 weeks,
after 3 weeks.
interim order is there.
Interim order pass earlier shall continue till then. Case there is here.
That's okay.
Case there will be returned back.
And the updated case very
And updated case there will be produced on the next date fixed. But give a date after 3 weeks.
November 6th, Lordship.
November 6th.
November 6th.
Like,
Keep this also in that file. Yes, why this matter is listed today?
Lordship, pleadings are completed and the matter may be fixed.
What is the issue?
Lordship,
What is the challenge in this petition?
quashing application. We are on
Quashing of
FIR number 103.
page FR.
Annexure 1, page number 19. Sorry, Your Honor, it's page number 18.
The POCSO matter, Your Lordship.
POCSO matter.
And Your Lordship.
This court is of the opinion that the informant in which case?
In POCSO.
In the respondent number 2, respondent 2 is not it, is not a necessary party in as much as the grievance of the petitioner is against an order dated
16/10/2023.
16/10/2023, whereby the learned special judge POCSO has directed to register FIR against the petitioner under section 120B, read with section 195A IPC, full stop. The fact also remains that the petitioner is not an accused in Tawang WPSC number 02 of 2023 under section 10 of the POCSO Act. See the page 16 if you are confused with the numbers. Page 16. Accordingly, list this matter in the admission column after 2 weeks. Yes, what is this?
Lordship, I'm appearing for the appellant herein. I am a victim represented by my mother. I'm challenging the acquittal of the accused in a POCSO case.
Okay. Parties are represented.
Lordship, I'm on behalf of my senior counsel. Petitioner
No,
went for, a petitioner went to Uttar Pradesh for holidays during this recent holiday. Petitioner went to Uttar Pradesh for during this recent holiday and has not returned yet. So next date may be given.
No,
To file
tell
for
us.
rejoinder.
Tell us, this is an
Sorry.
criminal
Lordship,
petition.
I'm sorry, Lordship. I thought this is item 15.
This is different case.
Huh?
I thought this is item 15, Lordship.
No, this is item 14.
So I'm sorry, Lordship. I'm sorry. Please forgive me. My bad.
Lordship,
Item
item 14 is not
14, Your Honor.
Huh?
This is 14.
You are on 14.
Yes, sir.
Okay, tell me what is the issue?
I'm for respondent. Last
You
occasion,
are
they
for?
petitioner.
You want an adjournment?
Yes, Lord.
What is the issue here?
Petitioner went to Uttar Pradesh during this recent holiday and has not returned yet. So next date may be
No,
given.
forget about, you are here. Each petitioner's presence is required in High Court.
But Lordship, I'm appearing on behalf of my seniors.
Maybe.
My lord,
You are appearing not on your behalf of senior, you are appearing on behalf of the petitioner. That's why a power is given to argue. Isn't it?
Yes,
What is the issue here?
actually, my lord, last time they have seek time for filing of rejoinder, and today's fixed.
What is the issue?
Actually, setting aside the impugned judgment of London JMFC Court
Okay.
in
On the prayer of the learned
maintenance
counsel
case.
for the petitioner, matters then
Lordship,
section and be listed.
interim order may continue till next.
Huh?
Interim order may continue till next date.
That is
Your
the most
Honor,
important.
last
We are
occasion
not
also-
extending the interim.
Last occasion also they have
We are not
Sec-
extending the interim.
they have taken adjournment, Your Honor.
Full stop.
Lordship, short date may be given.
Full stop.
So last chance may be
no.
given to file rejoinder.
Though time was granted to file rejoinder affidavit, no such affidavit has been filed by the petitioner. Matter is ready as regards service, and therefore list this matter in the admission column on.
2 weeks.
Give a date, not 2 weeks. Give a date after 2 weeks or whatsoever. You cannot do that much of time in deciding a date. We are
November
taking less
20.
time deciding
November 20.
matters, huh?
November 20.
November 20, 2024. In the meantime, the petitioner may file their rejoinder affidavit if so advised. However, same should be filed before the next date fixed. Full stop. No further adjournment shall be made on that day.
Ably ordered, obliged.
Obliged.
16. 15 was adjourned.
Adjourned, Lordship.
Yes. An
Lordship.
advocate has entered appearance from Manipur for the respondent number 1 for the first time today itself.
Lordship.
So
Lordship.
he requested for an adjournment, therefore we have allowed that.
Lordship.
We have
Lordship, what I am
we have fixed a date when? On 29th of November.
Lordship, what I learned is that he has said that the same has been done after consultation with us.
Maybe, but otherwise you have not. Otherwise, he has entered appearance only today.
Lordship.
So that's why on 29th.
In fact, 29th November.
We have already fixed that date.
Lordship.
Okay, because
It's
he's
a-
coming. He's an outstation layer. He is also coming from Manipur.
Lordship.
Okay.
Your Lordship, for the respondent number 567, DSGI is appearing. For respondent number 5, 6, and 7.
Which item?
Item 15.
Say my item, Lordship.
Okay.
DSGI is appearance for the respondent.
Preparing on behalf of DFG.
DSGI. Yes. Okay, DSGI name is not shown.
No, yes.
In the earlier order, you just
No, Your
reflect,
Lordship.
huh?
We have just received notice there. So.
I just received this.
You have also entered appearance today.
I received this petition today.
Yes,
This-
they have received instruction and they are appearance today for.
Okay, fine. That we need to record that. 29th. Okay.
Alright.
So fix it on 29th.
Lordship, because it's a victim who has come against the
And
acquittal.
we have direct we have service is complete today and appearance is made. So we have fixed
Lordship.
this matter in the admission column on 29.
Lordship. Highly obliged, Lordship.
Yes, next.
May I please, Lordship?
What is this IA?
Lordship, this is a matrimonial appeal.
Hmm.
This is, the IA is for condonation of delay.
Condonation of delay. Matrimonial appeal against whose judgment?
Against the judgment and order dated 29/9/2020.
Passed by
The District Court, UPR.
District Court UPR.
Lordship.
The divorce suit was under what provision?
Lordship.
It was a divorce suit.
Lordship.
Suit was filed under what provision?
It was filed under order 20.
Okay, not under Special Marriage Act.
No, not on.
Okay.
Yes, Lordship. Lordship.
You are for
Yes, your
Wife.
Lordship, I am for the respondent.
respondent wife or
Yes,
husband?
wife.
Wife.
And
So he sought a divorce that has been denied.
Your Honor, actually, the copy of the IA and the main petition is sub to me, soft copy was sub to me. So it was not legible, Your Lordship. And today I am
How
here
many
to
days
submit.
delay? How many days delay?
Lordship, the delay was of about.
Okay, give a copy to him legible. How many days delay? Tell us first.
Yes, Your Honor. So, and next day, I will file affidavit along with the Bakalatnama, Your Honor.
It is submitted by the learned counsel for the respondent wife that the copy served to him is not legible. Full stop. The learned counsel for the petitioner submits that he will furnish a legible copy to the respondent counsel, to the counsel of the respondent within a period of 3 days from today.
Yes, Lordship.
Accordingly, matter stands adjourned for 3 weeks. In the meantime, legible copies of the petition be furnished to the learned counsel for the respondent. And the respondent may file objection if so advised. Please this matter after 4 weeks.
Much larger. 663
Huh?
days. 663 days.
So therefore, we'll-
Obliged.
what is this IA?
I is for staying of the money execution, which they have filed in judgment and order in a NIA case, Lordship. Lordship, in this matter, there was an, I had issued a 2 check to the respondent on getting the notice from the honorable court, Lordship, like I had duly accepted, saying that amount I have that it's liable upon me and I'll pay that amount. So then during course of time, I have paid them 40 lakhs. And before the judgment, since there was no any evidence trial of the court, since I admitted of giving the check and they have legal liabilities. So the honorable court has said before judgment you paid the entire amount. So on that day, Lordship, I couldn't pay the amount because there was some, I had prepared the demand draft. The demand draft was prepared, but I couldn't produce before the honorable court. So the honorable court.
Now, how you propose? When will you pay?
Lordship, for that I have annexed the demand draft.
Forget about that. Now,
Yes,
when will you pay?
Lordship, I have paid the entire amount. The only the thing is that Lordship now the lower.
No, Lordship, the learned judicial magistrate first class has imposed 5 lakhs rupees as an interest. So they have paid the 65 lakhs. That is the actual
The
check
interest,
amount.
the instrument total.
Total amount was 65 lakhs.
Then now how much they have paid?
They have paid 65 lakhs, but not paid the interest imposed by the learned judicial magistrate first class.
How can Judicial Judicial Magistrate impose interest under what authority of law?
Lordship, under section 138 of
Where is the provision of imposing interest under 138? To us.
Lordship, this interest, Lordship, there are apex court judgments where this interest has been imposed. Clearly, yes.
Read 138.
Yes, Lordship.
138 is a penal provision.
Yes.
Yes.
Under punishment, and the magistrate is empowered to give compensation.
Correct, Lordship.
Where is that provision of interest?
The interest can be seen as
Where is that? To us.
Lordship, the interest can be seen as compensation under section
Where
257.
is the judgment? Tell us.
Lordship, yes.
Supreme Court judgment.
Yes.
Lordship, that also says that if the case go for trial, Lordship, since in here, Lordship, I have admitted the amount and I have paid, after my appearance, I have admitted, I have paid them 40 lakhs, and before the judgment on the same date, Lordship, I prepared a demand draft of 21 lakhs.
Lordship, there's another judgment wherein even after the accused has admitted that they are liable to pay, yet again, the Supreme Court has directed to pay the interest. Yes, Lordship. Lordship, para 18, 19, and 20, Lordship. Here, Lordship, the apex court specifically says that 9% interest, a minimum of 9% interest per annum should be imposed. May I read, Lordship? In this another judgment, Lordship.
Where is the paragraph?
Yes, Lordship,
Here
paragraph.
something different. It says that what happened in this case? Here it is a case where no compensation was paid, no compensation was directed, and no sentence was given. Okay, so Supreme Court did not interfere, High Court did not interfere, Supreme Court did not interfere. However, Supreme Court clarified that the earlier cap of 5,000 compensation has been removed.
Yes.
Now compensation is twice the same amount.
Yes.
Where is the interest? Twice the
Lordship,
same
Lordship,
amount. Now
paragraph.
tell us that
Yes, paragraph 18.
interest can be given.
Paragraph 18, Lordship.
Paragraph
18.
18 of this judgment.
Yes. Having reached that stage, if some magistrate go to the traditional view that the criminal proceedings are for
I will be
imposing.
enlightened today. That is the proposition of law. 18.
Yes, Lordship.
And page
Page 267.
267.
Yes, Lordship. Having reached that stage, if some magistrate go by the traditional view that the criminal proceedings are for imposing punishment on the accused, either imprisonment or fine or both, and there is no need to compensate the complainant, particularly if the complainant is not a victim in the real sense, but is a well-to-do financier or financing institution, difficulties and complication arises. In those cases where the discretion to direct payment of the compensation is not exercised, it causes considerable difficulty to the complainant, as invariably by the time the criminal case is decided, the limitation of filing civil cases would be expired. As the provision of Chapter 17 of the Act strongly lean towards grant of reimbursement of loss by way of compensation, the court should, unless there are special circumstances in all conviction, uniformly exercise power to levy fine up to twice the check amount, keeping in view the check amount and a simple interest thereon at 9% per annum, Lordship, and a reasonable quantum of loss.
You are not getting it. It says in all causes of conviction, uniformly exercise the power to levy fine up to twice the check amount. Okay. Now
yes.
in bracketed, keeping in view the check amount and the simple interest
Thereon.
9% per annum as the reasonable quantum of loss.
Correct.
It is not it has not authorized to levy interest. You can give compensation while keeping in mind the rate of interest.
So in this case, Lordship,
In this case, there is a specific award of interest, pay interest. That cannot be.
Lordship, this interest can be considered.
Cannot be.
Interest can be, Lordship, considered as the compensation amount, the loss which has been incurred to the complainant, Lordship.
Understand, the legislature in its wisdom has formulated a law which says and giving this power to the magistrate to compensate the complainant by paying compensation. Okay. Now that compensation outer limit is twice the SEC amount. Legislature has also said that this is outer limit is twice the SEC amount. Correct, Lordship. Now, while dealing with that case, in that case, at that point of time, there was the cap was only 5,000. Correct, Lordship. Okay, so Supreme Court says that this twice limit has been given, might be keeping in mind the rate of interest. It is not a proposition of law that magistrate can impose interest. A magistrate can act, or per se, we can also act when it is authorized under law, except certain powers under Article 226 or under Article 32 by Supreme Court or under Article 141 of the Constitution. Lordship. Lordship, in that case, this another judgment may be said, Lordship. So as. Lordship, in this case, paragraph, Lordship, 18(1), page number 571. Lordship, in this case, also the accused person had admitted the guilt and they had agreed to repay the amount. Meantime, they had given the demand draft to the complainant. However, complainant refused, and accordingly, it had gone for trial. Later on, they have tried to compound the case, however, which was denied, since there was no consent of the complainant. Now, Lordship. Here you have accepted. In that case, it was not accepted. No, in that case, the complainant did not accept the demand draft. That is why that was taken. But in this case, you have accepted the amount. Yes, in this case, this is the distinguishing factor between. Lordship, in this case also, even if I have accepted the amount, that amount was not given in one go. It was given the. Okay, let him go to jail for 6 months. You refund the 60 lakhs. 65 lakhs. And Lordship, like. In fact, Lordship. Lordship may kindly take judgment 21 also, like. There was no. Okay, we are not going to decide this matter today. We understand. Where is the IA? We are staying. Lordship, that matter is fixed for tomorrow. Lordship may come to paragraph 18, Lordship. Paragraph 18, Lordship. 18 of which? 18 on. Of the judgment which I have produced now. Yes, paragraph 18. Yes, here also it talks about the okay, interest. Let us read this. Yes. Offense under section 138, page 571 page 18(1). Offense under section 138 of the Act is preliminary as civil wrong. Burden of proof is on the accused in view of the presumption under section 139. But the standard of such proof is preponderance of probabilities. The same has to be normally tried summarily as per the provisions of the summary trial under CRPC, but with such variation as may be appropriate to the proceeding under chapter 17 of the Act. Now, Lordship. Thus read, principle of section 258 CRPC will apply, and the court can close the proceeding and discharge the accused on the satisfaction that the check amount with assessed cost and interest is paid, Lordship. And if there is no reason to proceed with the punitive aspect. For the purpose of even here, Lordship. That is for the purpose of compounding. You are not interested in compounding. Lordship, the compounding basically means they are willing to pay the entire amount and the matter is compound. Here also they are. Read the next paragraph. Yes, Lordship. 18.2 the object, 18.3. Lordship, yes. The object 18.2. The object of the provision being primarily. I will read for you. Though compounding requires consent of both the parties, even in absent of such consent, the court, in the interest of justice, on being satisfied, the complainant has been duly compensated. It can, in its discretion, close the proceeding and discharge the accused. Correct, Lordship. In this particular thing was. So we'll have our satisfaction on next date. Now we are staying in view of that he has already paid out of 65 lakhs. I paid the entire amount. Entire SEC amount. Yes, Lord. SEC amount already paid. So far relating to compensation, we'll take later on. So he should not be put into jail. Lordship, hard. This is IA. Yes, Lordship. The present application is filed for stay of the operation of order dated 25/9/2024, passed by Lorded JMFC, Capital Complex Arunachal Pradesh, in execution petition number 4 of 24. What is execution proceeding? We do not know. This should not be an execution proceeding under. No, this was not the execution petition. In fact, the actual petition was recovery petition. Tried the execution petition. Full stop. The connected Give the main file. Connected criminal revision petition number 17 within bracket AP 2024 is filed assailing the order dated 15/7/2024 passed by the learned JMFC, UPIA, Arunachal Pradesh in CR case number 29/2023, convicting the petitioner under section 138 of the Negotiable Instrument Act 1981 and was sentenced to pay fine of compensation. What is the amount? 5 lakhs. Compensation of 5 lakh inasmuch as during the proceeding, the compensation or interest
as interest to the complainant.
Interest of amount of rupees 5 lakhs to the petitioner inasmuch as during the proceeding, the petitioner had admittedly paid the amount paid the said amount, which was dishonored. Full stop. The learned counsel for the petitioner argues that in terms of section 138 of the Negotiable Instrument Act, the magistrate is not conferred with any jurisdiction to pay interest, though it is empowered to pay compensation with an outer limit of the twice outer limit of a sum twice the amount of the sick. Countering such argument, the learned counsel for the respondent argues that though the sick amount is paid, the petitioner has not paid the interest amount inasmuch as a magistrate is competent to compensate the accused, compensate the petitioner, compensate the petitioner, and the application of the word interest shall not make such award of compensation bad. Full stop. This method needs further consideration. In view of the effort of considering that the said amount has already been paid and what is remain to be paid is an amount of rupees 5 lakhs, this court is of the view that till final consideration, the impugned judgment dated 15/7/2024 passed in CR case number 29/2023 shall not be executed. That's possible. You want only 5 lakhs. We may interpret in that way that yes, though word is used as interest, but it amounts to
Lordship, at
compensation.
least one opportunity be given to me to prove that and come with some more judgments that.
No, we are
interest.
not deciding it.
Yes, yes.
We'll decide till this decision. See, please understand. Admittedly, magistrate cannot give interest, but at the same time, magistrate is empowered to give compensation. So whether only use of the word, your argument should be there.
Yes.
Whether the word interest itself will vitiate the entire award of compensation. At the end of the day, this is the compensation. In fact, you have been paid less compensation, though it is a discretion.
Correct. That
Isn't it?
I was
So
coming.
your
that-
argument should be in that line, not in that line that I have a power to influence. So therefore, we'll examine this method. Since he has paid majority for 5 lakhs, we do not want to send him to jail.
Then Lordship, a very short date may be given
Short
because
date, short
they
date.
have
Give it,
taken.
give it.
Lordship, LCR may be called.
LCR not yet received.
Not received.
Okay, this is in the IA. Okay. IA stands disposed of. Okay, now in criminal revision petition, what is this IA 84, na?
Yes, Lord.
And what is this IA 82?
82 was also for staying of that
Earlier.
earlier order. That has become infractuous. you would say.
Okay. Then you write in I criminal IA in view of order passed in IA criminal 84 within bracket AP 2024. This IA stands closed. That is IA 82. Okay. Both are closed. Now come to criminal revision petition. In this matter, notice was issued, yes, on 27/9/2024. First of, parties are duly represented. First of, in the considered opinion of this court, to properly deal with the challenge made in this case, the LCR may be required accordingly. Call for the LCR from LCR of so and so that UPR case, CR case number so and so from so and so. You have an arguable case. Lordship. Review of that. In item 13, okay, interim order pass earlier shall continue. In item, you took the dictation, item 13. Okay, just there. Yes, item
19, Lordship. This is an interlocutory application under section 5 of the Limitation Act 1963.
How much delay?
This 72 days delay.
72 days delay. You are the victim.
I'm for
You are the complainant.
Yes.
Complainant. Your appeal dismissed. Your claim dismissed.
Yes.
Or you want enhancement?
No, I want this delay condonation.
That we know.
Yes, matter was dismissed due to non-submission of Form 54 in the court below.
Against dismissal.
Against dismissal, yes.
Just write down. The present application is filed for condolation of 7 to 2 days delay in filing the connected MSC appeal being MSC appeal number 05/2024, challenging the legality and validity of the judgment and order dated 21/12/2023 passed by the learned member MACT UPIA in MSC case number 14 of 2013, dismissing the said claim petition. First up, the Mr. Swenso,
I am Eve Deka, Learned Counsel.
Deka, Learned Counsel for the
respondent
corporation.
Yes,
has entered appearance, and in his usual fairness submits that he has no instruction to object the condonation of delay of 72 days. Full stop.
Yes.
Peruse the pleadings made in the application. Full stop. The delay has been explained in paragraph. Para 6.
Yes.
Para 6 of the application. Full stop. Perusal of the same. After perusal of the same, comma, this court is of the opinion that there were sufficient causes which prevented the petitioner from approaching this court within the prescribed period of limitation. Accordingly, the delay stands condoned. Full stop. Delay stands condoned. I stands disposed of. In main MSC. Heard so and so. This is an appeal under section
173 of MB Act.
173 of the MB Act for setting aside the judgment and order dated 21/12/2023 passed by the learned member, MSCT, Papumpare district at UPIA, Arunachal Pradesh, in MSC case number 14/2013. Full stop. peruse the ground of appeal, also heard the parties, full stop. Admit this appeal, call for the record.
LCR.
As parties are duly represented,
Yes.
no formal notice need be issued. Full stop. Registry to list this matter in the order column after receipt of the LCR.
Most simple.
Yes, what is this?
My lord, this is a joint quashing petition.
By, please tell us where is the affair?
At page number 15.
Page
Page number 15.
15.
15.
Husband-wife dispute.
Husband, wife.
Husband and wife.
Registered under
498A.
just write it down and give it to Nat. 498A, husband and wife. Which paragraph? Compromise.
At page number 27.
Page 27, paragraph.
Paragraph. Page number 9. At page number 9, paragraph 9.
Paragraph 9. Page number 9. Paragraph 9.
9.
27 is the settlement deed.
Okay. Now paragraph 9. Okay. Paragraph 9. And settlement is at page
27, your lordship.
You are living happily.
Yes.
Okay. Yesterday we found that somebody, both are living happily with different persons. Okay, disposed of.
How like?
Please, your lordship.
Yes.
My lord, this is also a joint petition, but the FIR was lodged against the wife, the co-wife and the husband. The man is two wives.
Either two wives.
Two wives. The petitioner number 1 is the accused person. Petitioner number 2.
Just a minute. Just write it down.
But
Petitioner number 1 is the
lordship,
accused.
I would like to apprise that the FIR has been lodged under section 307.
Okay.
So if my lord,
What is the injury and all?
injury report is at page 72.
Page 72.
Yes. Lordship will see there are, the attack apparently has not been done on any vital parts. Page 62, sorry, page 62 and 63
Page 62.
and 63. Merely the 307 has been mentioned, but the alleged weapon of offense was a blade. And this is the injury report. Lordship may see at page 62 also. No vital part has been injured.
Others are simple.
Yes.
1 to 5 injuries. Others are simple. One is grievous.
Yes.
We'll adjourn this matter. You take a chance.
Lordship, Lordship may see page 63, Lordship.
Page 63.
Yes, this is the second injury report. Lordship, what I want to say, Lordship, is that just because 307, your Lordship knows.
No, that I understand.
Yes. So what I'm trying to argue is that just because these things are.
Only 307 may not always attract.
Yes,
307.
yes. What I'm trying to say is not the nature of the injuries, but whether the vital parts were targeted. That is what will. Yes, that is what will attract.
Even simple injury.
Yes.
If it is by a sharp weapon, but it missed it, suppose near head.
Yes.
But weapon was a sharp weapon, attempt was in the vital part.
Yes.
But injury is simple. Then also 307 will.
Yes, whether vital parts. Now, Lordship, as per the judgment of this honorable court regarding the vital part, I'd like to submit one citation, Lordship.
Give us.
This is this was the case. This is by the Guwahati High Court. Paragraph 14, 15, and 16. This was a case in which the neck of the complainant was targeted. In that context, Lordship may see paragraph 14. The learned counsel for the petitioner submitted before me that the neck of a human being is by itself a very sensitive and vital organ of the body, and any attack on such vital part of the body by itself should be considered as murderous, and such attack by itself constitutes an offense under Section 307 Indian Penal Code, and the prosecution has at least proved the prima facie case under Section 307 Indian Penal Code by proving that the attack was on the neck. I'm afraid I cannot agree with the contention of the Learned Counsel. It is true that the Learned Sessions Court has come to the conclusion that the neck by itself is a vital organ of a human body, but I am of the view that the neck is only an organ of human body which is situated between the shoulder and or thorax and the head, and like many sensitive organs of the body, this may be one of such sensitive organs. Any standard medical dictionary would show that the neck is one of the important organs of the body. The word vital is very relative. Any part of the body which may be said to be supporting or necessary to life or life-giving or essential to highly important can be loosely termed as vital. In the loose sense, it is undoubtedly a vital part of the body. Now, para 16, in neck itself, there are parts of which, if attacks are made, the same may be fatal. As for the instance, the windpipe is one such part of the organ on which, if much pressure is applied, it may cause death. It has been stated by the doctor examined in connection with the case that in the organ of the body called the neck, there are parts on which attacks are made. They may be fatal or mortal or calamitous. It is undoubtedly true that there are some spots or places in the organ called neck on which if assaults are made, may cause death. Unfortunately, in the present case, the medical evidence also do not go to show that such parts of the neck which might have caused death was attacked by the accused. The injuries found by the doctor were nothing but simple abrasions. There is no evidence that the accused held those parts of the neck which are the fatal parts of the neck. Under such circumstances, when there is no evidence coming from the prosecution that such murderous attack was made by the accused on any such fatal part of the neck, I cannot persuade myself to hold merely by stating that the attack was on the neck, and that too by hand, by itself is sufficient to establish even a prima facie case against an accused to face a trial before the court of session to meet a charge in which a person may be convicted for life. Now, Lordship, what I'm trying to say, the circumstance, the victim, the co-wife, she was at that time having an affair with the husband of the accused person. The accused person got wind of that, and then she went to the house of the uncle of the victim husband.
Let us see the affair first.
Yes, Lord. There are two FIRs, but one was, since it is on the same, I think the second one was registered.
Where is that
FIR,
first?
Lordship. It is at page 32.
Yes.
32. Page 32 and 33, but Lordship, I think it would be better to see page 36. This is the complaint which has been reflected in the FIR.
Page 36.
36.
Okay.
FIR, date is 9 May 2024. This FIR has been lodged by the father of the one of the victims.
Just tell me.
Yes.
Now this Sri Dai Talang is the informant.
Informant.
Now, a present ours, who is, he is also petitioner here.
Yes.
Petitioner number.
Petitioner number, not it's already. Dai Talang is petitioner number 3.
3.
Yes.
Okay. Now, Miss Mary Gadi
is petitioner number 1.
Petitioner number 1. And Sunday Gyadi.
Sunday Gyadi is petitioner number 2.
Petitioner number 2.
Deepak Talang, one of the victims, the husband, is petitioner number 4.
Deepak Talang is a party here.
Yes, petitioner number 4.
Petitioner.
He is the one for whom both are fighting.
Okay. Deepak, and who is Miss Nepi?
Nepi Cherry is the victim, one of the victims.
So Deepak is a victim.
Yes, Deepak and Napi.
And Napi.
Yes.
Napi is petitioner number?
Napi is petitioner number 5.
Petitioner number 5.
Yes, and also there is another petitioner that is Tado Chiri. He had also given information which is at page 37, same,
Okay, Tado
Cherry.
Cherry.
Yes.
His petitioner number
His petition number 6.
6. Now tell us the relation.
What happened is, Lordship, although
In a paper and a glass of water.
Lordship, Mary Gyadi,
Okay.
Mary Gyadi, the petitioner number 1 and also the accused person, is the wife of Deepak Talang, petitioner number 4. Now,
Wife of
petitioner number 4,
P number 4.
who is also one of the victims.
Accused.
Yes. No, petitioner number 1 is the accused, Mary Gyadi. Mary Gyadi is married to petitioner number 4, Deepak Talang, who is also one of the victims. Then what happened is he was having an affair with petitioner number 5. Now they are married, Napi Chiri.
Now P4 and
P5
P5
are married.
were in a relationship.
Were in a relationship. Petitioner number 1 got wind of it.
Relation,
And yes.
Now P4 and P5. P5 is also an accused.
No, P5 is a victim.
Okay, P5 is also victim.
Petitioner number 1 is accused of assaulting petitioner number 4 and 5. 4 is the husband, 5 is the at that time girlfriend of petitioner number 4. Now wife. Now she got wind of that affair and she looked for him. Then she got to know that he's in a certain place at Bebo Colony in Sepa. When he opened the door,
Just a minute, New Sepa and assaulted my son, Deepak Talang.
Deepak Talang, his petition number 4.
He is petitioner number 4.
Yes.
Deepak Talang is petitioner number 4.
Yeah. Yes.
Deepak and Mary are husband and wife.
Yes.
Okay.
Yes. And Napi Chiri is his girlfriend at that time.
Okay. So basically it's a fight between Mary, Mary, then
Deepak and Napi.
Deepak and
Napi.
Napi.
Petitioner number 5.
4 and 5.
Yes, 4 and 5.
4 and 5. And others are ancillary.
Others are ancillary. Petitioner number 3 is this is Dai Talang, who is the father of the informant. Then petitioner number 6, Tado Chiri, is also an informant. Then petitioner number 2 is the brother of Mary Gyadi, but he is a minor. He is a minor, so charges have not been framed against him. Now, what happened is, Lordship may see the circumstance also. She found them in bed. Can I use the word red-handed? Yes.
They were in a compromising position.
Yes.
Then she, out of anger, she attacked her.
Yes, that is what happened actually.
Now, ultimately, the marriage is dissolved. Now they are living separately.
No. Now he's married to both the women.
Both the
Both the women.
Where is that?
Lordship.
So even after this assault,
Yes.
he's still in love with his first wife.
Yes, Lordship.
Or out of compulsion.
Yes. It will be in the agreement, Lordship.
What is that agreement?
Agreement is page 85.
Page 85.
Yes. Lordship Messi, number 2 in the deed of agreement, N, after N, after 2, the second last paragraph, whereas parties are co-wives and the first party being second wife, second party being first wife of Deepak Talang, whereas the father-in-law of both the party had filed FIR on second party of this agreement before the officer in charge, whereas on result of a complaint was registered and subsequently both parties amicably mutually settled the matter. They say,
Okay. We'll deliver this order on Monday.
Yes, Lordship.
I'll just go through it and 307 we'll record your objection.
On 7, Lordship.
We'll record your objection. It is a case that it is a 307. So therefore such kind of cases should not be allowed to be compromised. This will be your argument.
Lordship,
And
here
because these are compromised, this is having an impact on the society.
Lordship.
Okay.
Lordship, moreover, Lordship, this injury, Lordship, it may not be in vital, Lordship, site, Lordship, but it is, Lordship.
By sharp weapon.
Lordship, and it is, Lordship, may go to the record also, Lordship. It is by face and something like that. It is very severe, Lordship. That
No report is there.
Lordship.
Here, total 3, 4, 5, 6 injuries are there.
And also more
So
of-
multiple injuries.
Lordship.
That will be one of your ground.
Lordship.
There are multiple injuries, and by a sharp weapon.
Lordship. Moreover,
So
Lordship.
intention was clear.
Yes, Lordship.
And one
By
injury
trespass also, Lordship.
is
they-
grievous nature. Even if
Lordship.
it is assumed that it is not 307, but it will be a grievous hurt, which is again non-compliant. This will be your argument.
Lordship, moreover, Lordship, one point I have to note, Lordship, this statement of the Lordship, this victim father, Lordship, this boy father, his statement, Lordship, deposition as well as in 161 statement, he, Lordship, denied the relationship, Lordship. He denied that they have mutual some marriage ceremony was there, Lordship.
What
May
is
go
the
through
stage?
that, Lordship.
What is the stage now? Search sheet is filed.
Now, it
Trial
is
begun,
fixed,
Lordship.
trial has started, it is fixed for PWs. Some PWs were examined, then,
Who are those PWs?
all this, which I have mentioned.
Now, what is their stand?
The
In-
accused
They have,
statement.
they have relied on their 161 statement that whatever was stated.
No, what they have deposed before the trial court?
The cross-examination has not been done yet.
In chief,
In chief, they have said whatever was stated in the
then it
161.
will be difficult.
Yes,
Compromise is dated.
compromise, Lordship.
Nikita, it will be better for you to complete the cross-examination.
Lordship, we were,
Why I'm
it was fixed, Lordship.
why I'm saying is,
Yes,
in the meantime, trial has commenced.
yes,
A statement on oath before a competent court is already there, where implications is made against you, if they are gone by 161.
yes.
And they have not stated as regards this compromise and all.
No, Lordship, compromise was done
Subsequent.
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 Yes,
So there may be an implication allowing this kind of petition that when evidence went against you,
Yes.
it was a compromise, maybe under duress and all. See, as a judge, I will have to think all is all fair.
Yes.
Because already evidence is there.
yes. No, Lordship,
So therefore, it
we
is
were-
better to have the cross-examination completed
yes,
and come back. I think that is the best option. Otherwise, it will be difficult because I'll have to handle it. I'll have to say that how I will deny the statement which is not yet cross-examined,
yes,
which is consistent with the 161, which will have a better proposition. The evidence before a court, not a compromise between the parties. In
Yes.
more particularly in a case under 307, we'll adjourn this matter.
Lordship. Then, Lordship, the
You
cross.
complete your cross-examination, come and say that this is the thing, nothing to be survived.
In
I
that-
think so. This is a better.
May I pray, Lordship? In that case, this may be adjourned for 2 months, Lordship, because
We were on the prayer of the learned council for the parties, matter stands adjourned for 6 weeks.
obliged.
I think that is better.
Bless us.
Well, this is civil revision petition, my lord.
Lordship. Yes. What is this? Civil revision.
Civil
What is
revision.
this?
Lordship, I am agreed by the decision of the village level cover firstly, whereby the respondent has decided,
What is the issue? Tell us. What is the order impugned?
impugn order is Lordship, ADC Basar has referred the matter to the Bango level cover, Lordship. Bango, this is not existing for Lordship, under section 46(1).
So
Either
according
they
to
have
you, the order has been passed by an
ADC, Lordship,
ADC.
referring the matter to the Bango level cover, Lordship.
So he don't, according to you, don't have that kind of jurisdiction to send it this matter.
Yes, Lordship.
Or that to authority to whom it has been sent is not having under authority under law to decide the matter.
He has authority, Lordship, Under section 46(1) of AFR, either he has to try de novo or refer back to matter to the arbitration as per the section 38, Lordship.
No, understand. Now he has sent it to whom?
Bango level cover, Lordship.
So therefore, that is what you are proposing, that though he has a power of remand,
Yes.
but he is to remand to a specific authority prescribed under law, not under the Bango level
Cover.
committee.
Yes.
So therefore, your sum and substance argument is that the matter has been remitted or relegated to an authority which is not having authority under law.
Yes, Lordship.
This is your case?
Yes.
Now, my lord, initially, my lord, the village authority has taken a decision in my favor, my lord. Thereafter, my lord, two occasions, my lord, by this satisfying the order passed by the, my lord, the village authority, he, my lord, made a complaint before the, my lord, additional deputy commissioner. Additional deputy commissioner, my lord, he referred back to the Bango level, and he duly participated. On two occasions, my lord, the decision has been taken in my favor. He has not raised any objection. Now, my lord, the decisions of the, my lord, the village authorities, Bango level Keva, as per the reference made by the additional deputy commissioner, where decision has been taken in my favor, though he really duly participated in the, my lord,
So he
proceeding.
has not challenged the original
No,
order
my
of
lord.
the ADC?
No, my lord. There
I
is
have
no
challenge, Lordship.
Huh?
I have challenge, Lordship.
But you have, after participating, you have challenged.
Yes.
Lordship, I have challenged the Khaba, Lordship, firstly. Khaba was decided in between the respondent, Lordship. I was not a party, Lordship.
Oh, that case.
Yes, I was not the party. In the
Who is
Khaba.
enjoying this some
Res-
agreement?
respondent,
Some
Lordship.
payment? In this case, what is the dispute between both of you?
My lord, it is land dispute case, my lord. And the land belongs to me, my lord. And presently I am in possession. He never possessed the land, my lord.
Okay.
And it was, my lord, purchased by me from the village members. And my lord, I was in peaceful positions and occupations of the said
Now,
land.
next question will be, suppose he had participated
Yes,
in
ma'am.
a jurisdiction. Jurisdiction is a subject. There are two kinds of jurisdiction. When an authority is not absolutely having a jurisdiction, that can be challenged at any time. That is itself is nullity. Suppose a civil suit is above an amount which is to be decided by a civil judge senior division, is decided by Munsif. This will be a subject matter jurisdiction, not a territorial jurisdiction. Suppose a suit is to be decided by the civil judge senior division UPR, but has been decided by civil judge senior division capital region. Just I am giving an example. Then this will, and he has participated, then this cannot be a ground to set aside. Because authority is having the authority.
Correct.
The territory is different. But when this authority is not having any authority under law, that can be raised at any stage, even in the stage of Supreme Court.
Exactly.
So now the question will be whether that Kevang will having an authority under law.
Yes, ma'am.
To decide.
Yes,
If not, okay, some other day.
Well,
You have the judgments. That is the fundamental issue. Jurisdiction, yes. In certain cases, if you have participated, your right will be waived. But in certain cases, your participation or not participation is not an issue at all when it relates to the authority. Suppose a munsif is without authority taking matrimonial appeal, which is otherwise statutorily given to a district judge. Then if that,
Then,
whatever, it will go.
exactly, ma'am.
But there is some power which can relegate a munsif to deal with matrimonial appeal. If that power is there, then it will have.
Well, that is the exact the contention and objection raised by the respondent. The Bango level has jurisdiction, and he has also been duly
So
participated.
if Bango is having jurisdiction,
Well,
under authority, some semblance of right and jurisdiction, then of course. But if not, otherwise it will not. This is hearing matter. Because we are here, I do not want to keep anything CAV. We have fixed his method today so that we can dictate and finish up this method. So therefore, we are not taking.
After 2 weeks,
After 2 weeks.
develop.
As agreed to by the learned counsel for the parties. place this matter after 2 weeks.
Right.
An interim order, no.
No. Develop.
Yes, Fukan. We'll come back at 2.
Yes, yes, sir. Okay.
Thing ready?
Give you lordship, I have filed a FIR. So on the basis of FIR, what they have initiated investigation, that part only. Rest I don't
We'll see
have
your statements are there.
subject to the submission of.
It's a abatement of suicide.
Yes,
Registered
yes.
under abatement of suicide.
Yes, yes.
And we know the parameters of abatement of suicide. What are the facts we'll see and start acid at 2. Yes, okay. Yes, sir. We'll not do half. We'll, how much time will you take?
My lord, half an hour.
Half an hour.
5 minutes only.
5 minutes. And you? I will not take my time. According to you, what is the case? Any such kind of abatement which compels a person to commit suicide, any evidence to the effect, any materials. Normal, some emotional here and there will not do.
Yes, this is a case of same nature, emotion and something, there is a marital discord between.
So before hearing Mr. Fukan, I will go through the whatever the statement, first FIR, then statement, then if necessary, we'll give him half an hour. If we dismiss his petition, and if we allow his petition, thinking of that, then we'll hear Mr. Singh. We'll not even hear him. At 2.
The white file. In the last part, my lord. Last part. Page number 44 to 47.
To Rupa Police Station.
To Rupa Police Station, Bomdila West.
Bomdila West, Arunachal Pradesh, 23/7/2021. No, sorry.
Subject abatement to suicide. Complainant Sagar Prabhakar.
Just a moment. Page.
As per my translated part, it is 44-47. Last 2 pages.
42. Rupa Police Station, Bomdila, about statement of suicide.
Yes.
Huh?
Yes. Yes, Doctor.
44-47.
44-47. Same.
Same. Both are the one is 40-43.
Yes.
One is
same.
44-47.
Same. They type twice.
Okay.
May I go to the FIR?
Let us understand.
Yes.
Now, who is the petitioner here?
The petitioner are the wife, the
here
father of the
Poonam Uttam Patil. Who is Poonam Uttam Patil?
Is the wife of the deceased.
Wife. And Amol Uttam Patil
is the father-in-law of the deceased and the father of the no Amol Uttam Patil, my lord, sorry, it is the brother, wife's brother. Petitioner number 2, wife's brother. 3 is the
wife is petitioner number 1.
Petitioner number 1.
Amol Uttam Patil is P2.
Is
petitioner number 2.
Petitioner number 2.
Who is brother of the wife, brother-in-law of the deceased.
Brother-in-law of the deceased.
Okay.
3
now Uttam Dattari Patil
is the father-in-law of the deceased.
Petitioner number 3.
3. And petitioner number 4 is the brother-in-law of petitioner number 1.
He is also petitioner here. Petitioner number 4.
4 is the brother-in-law of petitioner number 1.
Okay.
Now, my lord,
informant
is the brother of the deceased.
Okay, let us read the FIR.
So, humble submission is that I, so-and-so, live in so-and-so. In my family, we are 3 members, my parents and me. In the year 2010, my brother, Arjun Prabhakar, so-and-so, joined
the deceased.
Deceased.
Arjun Prabhakar is the deceased, joined the Indian Army. Accused number 1 is the brother, my brother's wife Poonam. Accused number 2 is Poonam's brother. Number 3 is father of Poonam, and number 4 is brother-in-law of Poonam. On April 17, 2019, my brother got married to accused number 1. In marriage, the accused number 4 raised havoc and create a lot of hue and cry without any reason. Therefore, my brother asked accused number 4 about the reason of quarrel, but due to this, accused number 1 became angry and said that she would not let the marriage taking place in any condition. The accused number 1 insulted my family member. At the same time, accused number 2 and 3 also tried to break the marriage, but my parents got involved in it and said how it could be possible to end the marriage suddenly. Thus, the marriage was held on compromise. After marriage of my brother, accused number 1 stayed peacefully for some time, but at the end of my brother's 2 months leave, he joined his duty in Arunachal Pradesh. After some days, Poonam asked my brother to take her along with him. This is important, Your Honor. My brother was reluctant to do that, and he tried a lot to pursue Poonam to stay in that place. But getting angry over this, Poonam never properly talked to my brother over phone. Poonam used to quarrel with my brother by making false allegations against my parents too, due to which mental condition of my brother deteriorated. The job pressure in the Indian Army and the pressure of family dispute have made my brother mental health severely deteriorated. In 2019, on the occasion of Raksha Bandhan, Poonam pretended to commit suicide by consuming herbicide at home, as Arjun did not take her to his workplace, as stated earlier, that she wanted to go with him. Now, when Arjun came to know about it, he took leave and came home. He was very sad to see all the occurrences, and his mental health was also adversely affected. When Poonam's health recovered, we brought her to our home. Thereafter, accused number 2 and 3 quarreled with us and my brother in front of Sudarshan, Prabhakar, so-and-so, and Yogata, and verbally abused us. They told my brother to take Poonam to work. It should be workplace, or else to divorce her. Due to such demand, the mental health of my brother was badly affected. Then on our intervention, he gave consent to take Poonam along with him. Thereafter, Poonam and my brother started living in the soldiers' quarters in Arunachal Pradesh. At that place, Poonam quarreled with my brother. Poonam asked my brother how much money that he has saved after 10 years of service. This is another point to be noted. Then my brother told her that he had invested 10 years of earning for renovation of his house because of poor financial condition of the family. And from now on, he would spend the salary for their own family. Poonam said that her brother-in-law, that is accused number 4, is working with him. He has brought house and plot of land for own use, but my brother has not done anything. Telling thus, Poonam quarreled with my brother and told the army officers that the Arjun had assaulted her. Then the officers called my brother and told him to leave the job. And there has to be mentioned that for his good performance, my brother got promoted in army in the year 2018. But due to Poonam's misdeed, my brother mentally suffered a lot. When Poonam narrated the incident to her brother-in-law, accused number 4, called the officers of my brother's unit over phone and told lies against Arjun and asked them to take judicial steps against my brother. When my brother asked accused number 4 the reason of his doing this, he abused my brother and threatened to terminate him from the job. Arjun told me all these things over phone. Accused number 4, Poonam, that the mental state of my husband was, he spent all the money on the family. He could not and he would not do anything for her. In this way, he misled Poonam. Hearing this, Poonam quarreled with my brother. It is stated the accused number 4 has stated. Then the army officials, accompanied by others, humiliated my brother and calling him a mentally ill patient, admitted him in mental hospital of Guwahati. This is wrong, Your Honor. This is 151 base hospital at Guwahati. This is not mental hospital. When I accompanied accused number 2, Poonam's brother, to meet Arjun in the unit, Poonam humiliated my brother in front of me and said that she did not want to live with such a senile person. Moreover, Poonam's brother abused and insulted my brother and threatened to terminate him from his job. And by mentioning about his acquaintance with higher officials, then my brother requested Poonam to stay with him, but Poonam refused to hear him and went away with my brother. So Poonam left the place. Due to the above mentioned incident, the mental state of my brother became very bad, and then we tried hard to convince Poonam over the phone. While talking to him over phone, it seems that he was under a lot of mental stress. My brother told me and our brother-in-law that how much mental torture Poonam and her family had inflicted on him. Keeping an eye on his salary and funds, Poonam and her family demanded money from him several times. After marriage, without giving any marital happiness, Poonam asked my brother several times to divorce her. While serving the nation, accused number 1 and 4 tortured my brother mentally and physically by calling him as a senile person and instigated him. Now, this is the only line. Instigated him to commit suicide. Due to all this, on October 19, 2019, while on duty in the army, my brother committed suicide by hanging himself in a tree in the army camp by using Poonam's cloth, chunni. Within 6 months of marriage, accused number 1 to 4 instigated my brother to commit suicide. Therefore, I request you to register an FIR against the accused number 1 to 4 for abetting my brother Arjun to commit suicide by torturing him mentally and physically, and to take legal action against him and thereby giving justice to me and my parents. Now, Your Honor, documents attached with the document attached with document 1, Rupa Court of Enquiry Investigation Report. Your Honor, it might be in the case diary, but we have enclosed the, it is in page number 25 of our petition. It's a part of the FIR. It's the Army Court of Enquiry Investigation. Page number 25. Annex 2.
Yes.
Huh?
Flag.
May I go through? Finding of the court. Number so-and-so, Sepoy Arjun Prabhakar was enrolled in the Indian Army 102 Engineers Regiment on 19 March 2010 and was posted as GE 859 WS on so-and-so 19 Form 102 Regiment, White, movement order written so-and-so, and the copy of the movement order is produced as Exhibit 8. The individual has put in 9 years and 7 months of physical service. He had 2 red ink entries in his service record. The individual has been awarded 3 days of rigorous imprisonment for consumption of alcohol. My lord, this is very important because on subsequent finding also the same thing reflects by CO of 2 Rashtriya Rifles Battalion number 5 on 5 March 2015 in the first instance, and 7 days of rigorous imprisonment for sleeping while on sentry duty on so-and-so. Field conduct state of the individual was produced as Exhibit 9. So-and-so in respect of individual, point number 3, individual has earlier initiated on 28 April 2015. He was admitted at BS Barakpur. The individual was placed in low medical category S3 with effect from 19 September 2015 to 4th March 2016. White Part 2 order dated so-and-so for disability adjustment disorder and dependent abuse of alcohol. My lord, marriage was conducted on 17 April 2019. It is prior. I'm speaking about what is mentioned prior to that. Again, individual was placed in low medical category S3 with effect from 4th March 2016 to 19 August 2016. Part 2 order that is so-and-so for the disability of adjustment disorder and non-dependent abuse of alcohol. But the same has been produced at Exhibit 20. The individual was upgraded to low medical category S2 with effect from 19 August 2016 to 3rd February 2017 by order dated so-and-so for disability.
What is the date of suicide?
19 October 2019. The same was been with effect from Iman. The individual was subsequently upgraded to for disorder and dependent abuse of alcohol and continue to remain in that medical category S2 with effect from 3rd February 2017 to 21st July 2017. White Part order so-and-so, White Exhibit 21. The individual is subsequently upgraded to medical category Shape 1 by caption for Grace Specialty Psychiatry on 158 Base Hospital at 12 August 2017 has been produced at Exhibit 22. The individual was married to Poonam Patel on 17 April 2019 at Nasik. Maharashtra, as per Hindu rights, marriage certificate has been produced as Exhibit 4, Exhibit 11. However, Part 2 order for the marriage certificate for so and so and other requisite document has not been carried out till 19 October 2019. This is also an important point, why this case is going on, Your Honor. Now, coming to this, these are the leave days. Coming to the second case, my lord, case number 26. May I continue, my lord? Base number 26. While serving in GE 859 EWS, the individual was detailed for administrative duties during the period 28 July 2019 to 23rd August 2019. The individual had sought interview of OC Troops GE 859 EWS Captain Asutosh Sharma to request for emergency leave. During the interview on 22nd August 2019, the individual informed OC Troops regarding some dispute between his wife and his parents, and his wife was threatening him that she will consume poison if he do not intervene. The individual was granted 20 days casual leave for the year 2019 from 24 August 2019 to 12 September 2019. Leave application of the individual has been produced as Exhibit 10. The expiry of the leave, the individual brought his wife to the station and was allotted government merit accommodation at Lower Dahom with effect from 14 September 2019. And it is exhibited by Exhibit 12. Now, this is corroborates what the FIR states, that she threatened to consume poison and she was eventually brought. Now, on para 8, on 26 September 2019, the individual was found in an intoxicated state and has physically assaulted his wife at government merit accommodation allotted to him. When he was advised to stop assaulting his wife, the individual reacted violently to the extent of abusing and throwing stones at officers and NCOs of GE 859 EWS. The individual had to be overpowered, subdued, and admitted to 181 Medical Hospital. His was also administered first aid at 181 MS, statement of witness number so and so. Now, 9. Post-domestic violence incident on 25th September 2019, GE 859 EWS approached family members of the individual and his wife to take back her to their hometown. Mr. Walanju Sagar Prabhakar, this is the informant, younger brother of Arjun Prabhakar, and the brother of the individual's wife, brother means petitioner number 2, in the station. Subsequently, the individual wife left the station for her hometown on 7 October 2019. This is to be noted. 7 October 2019, along with her brother and Walanja Arjun Prabhakar's brother.
Yes, what is in your case, Daddy? The lateral paper plague, which I have put is, I think that is relevant for this case. Horizontal is the main document. Yes.
So I have very limited to say. Worship, pursuant to the FIR of course that reveals some kind of privacy material against the accused persons. In pursuance to the said FIR, what the investigation has taken place?
Same statement I have seen. Whatever stated in the FIR is the same. Only ground is that she wanted divorce. She wanted divorce. They have threatened that higher officer will be intimated. So therefore, under mental pressure, he has committed suicide. Will it amount to an abatement? If everything is taken to be correct, we are not going whether you are wrong or we are accepting everything to be correct. Yes, we will not say this cannot be, this could not be. We are not saying. What we are saying is that we are accepting the statement made written in the FIR are correct. We are saying that statement recorded under 161 are correct. And also you are saying that whatever material annexed with the petitions are also correct. Whether it will lead to a prima facie case or a case when it is abatement of suicide.
This is a part of investigation.
Nothing more is required. But here is there is no other person. Who are the witnesses here? The informant is the vital witness because there is no suicide note. Suicide note is not here. If suicide note is not here, he talked with the brother. So we are accepting that whatever brother says is correct. And other part is his persons from the unit. No other witness are required.
The person from the unit, that is the proceeding before the army.
No, that we are not saying that on the basis of that there can be suicide or not. That is only facts. They say he had mentally ill, this, that. We are also not going to that. And we cannot say that they are correct, therefore it cannot be an abatement. We cannot say that because that will be a scar upon a dead person. Yes. Who died, and we will declare him to be a mentally ill, which in fact his station was upgraded. But these are the facts before us, that's all. We are not commenting anything on them. But on the basis of these facts, if everything is taken to be correct or whatever before us, can these persons be allowed to face trial?
There was a quarrelsome life. There was after the marriage. There was a quarrelsome life.
Quarrels is admitted. Quarrels are admitted, but abatement will be to a certain extent, which normal, that is then defined. Nowadays it is settled proposition of law. Quarrel and committing suicide cannot be directly said that it is an abatement. To take the status of an abatement, it is something different is required. Okay, hearing concluded, judgment reserved. Hello, time system remains on my. You want to add anything?
Your Lordship, may I submit?
Yes.
There is a translation copy. I suppose there is a copy is also there.
You have?
No,
there is a separate file for translated copy.
Yes,
Translated copy.
translated copy. There must be there.
Yeah, it is here. This is the file.
Here is the last conversation. Last conversation between the deceased and his Jija.
So please show us.
Here, he oftentimes express his dissatisfaction with their marital life and the conduct of his
no
wife.
Doubt about that. He was not happy at all with this lady. This lady was demanding you construct houses. My brother-in-law is done doing. You construct houses. Where have you spent the money? And that you give me divorce.
These are the three fundamental allegations. And she acted by consuming poison as if she is committing suicide. So this is the situation under which he has committed suicide.
It's stressful life.
Huh? He committed suicide.
Yes.
Now what is abatement? Let us read it. Read it.
It's as per the notes, comments on the section, abatement of suicide. Firstly, need to establish conduct of accused which drove deceased to commit suicide. It's a sine qua non is a case of abatement of suicide and cruelty. This is the first condition. Second, abatement involves a mental process of instigating a person or intentionally aiding a person in doing of a things. Without a positive act on the part of the accused to instigate or aid in committing suicide, conviction cannot be sustained. That is a second ground. Third, words uttered from the husband to his wife to go and die while quarreling and wife committing suicide after 2 days, what said suicide was not proximate to the quarrel.
What is abatement?
Abatement is aiding.
Abatement. What is abatement?
Aiding
Just take a
someone to do something.
Huh?
Aiding or
abatement is defined where?
Instigating or aiding.
Abatement is defined where?
Whoever abates the commission of something.
What is abatement?
It's a sort of instigating.
No, what is defined in IPC?
It's
section. Come to section 107. You must be ready while opposing. You will not say that abatement is something instigating. What is abatement? Come 107. Reading.
Yes, a person's abates the thing of a person abates the doing of a thing who first instigating any person to do that things, or secondly engage with one or more other persons or person in any conspiracy for the doing of that things. If an act or illegal commission takes place in pursuance of that conspiracy and in order to the doing of that things, or thirdly, intentionally aid by any act or illegal omission the doing of that things. Explanation. First, a person who by willful misrepresentations or by willful concealment of a material fact which he is bound to disclose voluntarily causes or procures or attempt to cause or procure a things to be done is said to instigate the things, instigate the doing of that things. First, who instigate any person to do that things? What my understanding is that this conversation is a dying declarations of the basis.
What do you say?
This conversation, Your Worship.
Which is dying declaration? Please, you are a counsel, make a responsible statement. Which you are to say dying declaration?
Here
Which translation? So us?
Actually, this is not paginated because
no, not paginated, but tell us when. Well, please show us in this file, please may mark the flag dying declaration.
Here it is vast and not paginated.
No, you see it from this file, same.
This is the same copy, Your Worship.
I think same. Is that Mr. Fukan look at this?
I have marked.
Which just mark it in my file. Which conversion, Mr. Fukan? What conversion is say? I don't know.
He even
conversation between whom?
Between him and
Jijaji.
Huh?
Between
his brother-in-law.
This is and brother-in-law.
This is and his brother, not brother-in-law. Brother-in-law.
Oh, yes.
Who recorded it? Conversation between you and me.
Yes.
I am already gone. Now, who said that this was the talk between you and me?
It was from CDR.
Huh?
There it CDR was collected.
phone is recorded. CDR is a thing where it is seen that so and so called so and so in so many times at this time. Is it any recording?
It's a last conversation means.
Please show me from where. Give your file.
Conversation.
Huh?
There is a conversation is there, long conversation.
Marking both jagah mein.
And it also said the last call recording in respect of late Sri.
Continuous conversations. So
Which is Jesus Wilper.
I cannot specific. I just folded them. 10 mark outline.
We understand. This is recorded where? From CD, do you say that this was recorded, it was sent to the forensic and it was decided to be the recording? Where is the call record thing? You go through your case diary.
Yes, that is not there. CDR is not.
It is not there.
Not there. How can you rely on? Who translated this?
This part has been given by the petitioner. He wrote it and he sent it to the police. Let the prosecution speak on that. It is because this thing has been, there's multiple litigation is going on. Another domestic violence case is going on in Maharashtra. And these parts have been
Mr. Counsel, you are a responsible officer of the court. So you can make submissions only from your case diary.
Yes, it is translated from the case diary only.
Who show us the case diary?
That's Hindi written portion. Hindi written.
Please show us Hindi written portion. Please show us.
Right, this direction of this honorable court, it was sent to Guwahati for translation.
Principal bench.
That is fine, no doubt about this. I want to see how it was recorded. See, IO recording statement of the brother-in-law is fine. That the brother-in-law has said so and so, so and so. This is one matter. And it is saying that this is a conversation between the deceased and so and so. From where do you get this? Have you seized that mobile and recording?
Yes, mobile was seized.
Recording was sent to forensic. Please show anything. Mr. PP, do you understand what I'm saying?
Yes, I do understand.
See, investigation is done by IO. During the course of investigation, IO records statements of the witnesses under section 161 CRPC. Suppose he is the brother-in-law or brother, whosoever. Now, police interrogates him or takes his statement. He makes certain statement. Police records it. This is a statement under 161. Now, suppose he says, or somehow the police has gotten information that there was a recorded conversation of phone between X and Y. Okay? To use that as a piece of evidence or a part of the investigation, police will have to seize the phone. Number one. Number two, phone recording without authority of law is not permissible.
Yes.
You might have phone without authority of law is not permissible. Even if it is assumed that it is permissible, and you will have to send the voice sample and the phone sample authenticity, and if that is there, then only we can read this. If anything on record to suggest that.
Yes, as this your same bench has sent the same portion of the Hindi portion of the.
What is this? Now let us see.
For translation.
This is the page you want to say?
Hindi bunch of pages in between.
Which flag? This flag. From this to that. From this to this. To this.
And in middle portion of middle part of the CD also.
it starts. Till this,
There is one more flag mark is there.
till which page? That is what I'm saying. Till this page. Till this page. What is this? Let us understand what is this. To Rupa Police Station, investigation officer, West Coming, Bongvilla, Nation. Subject statement of applicant which were not recorded. Is that it?
Yes, there is.
Have you gone through it?
Yes, yes.
So the first letter says to Rupa Police Station, Arunachal Pradesh, statement of applicant which were not recorded. मैं सागर प्रभाकर बालूज रूपा पुलिस स्टेशन के विनम्रक लिखता हूँ कि मेरे अर्जुन भाई ने जी से ईडब्ल्यूएस में तरफ से लोअर डिवांग में स्वयं so this is his application. Last call recording in respect of स्वयं. So what he has done is he has recorded the telephone and translated it to and give it to you.
That's what I'm saying.
Can that be evidence?
Whatever there in the record, that I'm appraising this court.
Huh?
Whatever there in the record.
No, do you understand? लेकिन अब अर्जुन मित्र की जिम्मेवारी कोई लेने के लिए तैयार नहीं है, इसलिए मैं रूपा पुलिस से विनती करता हूं कि इस सभी घटना के दोषियों से गुवाहाटी में मेडिकल कैटेगरी में अर्जुन पहले अर्जुन now it's come last call record with Arjun with his Jija Sunil Pagar. Now where from this has been related, how it has been related, nothing is there.
Therefore, investigation has to be carried out.
This is a
In
question
the
of.
present case, there is no any investigation has not been carried, nor the statement of the informant has been recorded, Your Lordship, nor the other witnesses.
My lord, the FIR was filed
So
on
this is a initial
22nd.
stage of investigation.
This is absolute abuse of the process, nothing more. Okay, let us accept everything to be correct here. Okay, let us accept everything to be correct. What? Okay, what are the allegations? Which paragraph you want to say? Which paragraph you want to say? This is page 1.
Folded and
all
outlined by pen. That's my copy. And the court copy was there. Did you suffer from deep depression by the conduct
This
of
is a conversation between the deceased and
a brother-in-law, his brother-in-law?
deceased brother-in-law.
This is brother-in-law.
Meaning thereby brother of the brother of his wife, who is also an accused.
No, not this person.
His brother-in-law.
His brother.
From his side.
His side.
His sister's husband.
Sister's husband.
Okay.
My lord, I want
According to which is the sentence that has abated him to commit suicide?
May I then read?
You
Which-
just highlight it, you highlight, I'll
Ah,
take,
yes.
take it to my residence.
With my book.
I'll read once again. You highlight which are the sentences according to you is
Actually,
abated
There is
suicide.
no cell mark, so.
I have seen that.
And no paginations.
no, that not a single abutment is there to show that the petitioner has abated the suicide. Not a single sentence if the prosecution can show.
Firstly, because of her attempted to commit suicide
Where
by
is that?
consuming poison. She was, matter was intimated to the higher officer authority also, and she was subjected to the disciplinary. Matlab, she was.
She said he has tortured me, he has attempted to murder me. So therefore, the CEO said, I will suspend you, terminate you from your job. And therefore he says, after 10 years of service, if I am suspended at this stage, what remains? These are the 3 lines. And if somebody dies and at this kind of is an abatement if we held, then everybody will be under abatement.
Here, one sentence is there.
Yes, just highlight it. Highlight.
Jija asks the deceased. Everything happens coordinately. There is no need. There is no need for anyone to do many things. There is no need. The need is to talk to each other coordinately. This is what I was telling you earlier. I have no will to do something for myself, but just should I be treated well? Then again, he says, this is said, tell me what to do now. How should one live? There's that day, my CEO directly said that I will suspend you, I will dismiss you from the job.
Huh.
And you'll also again, there is one sentence. What to say? This is said. What to say? Since Punam came home, there is so much harassment. Again, Your Worship, only I'm coming to the 11%.
See, just understand, harassment and abatement are 2 separate and distinct. We will deal with all this.
Yes.
Harassment and abatement to commit suicide. There are 306 is a suicide, isn't it?
Yes.
Then 107 will come. How Supreme Court have interpreted 107 to combine with 306? What should be the abatement? What should be the level of that abatement which compels a person to commit suicide? You flag mark it, which according
Yes, one more sentence.
No, please highlight it.
Yes,
I will quote in the judgment.
Yes, but listen.
Give him a pen, colorful pen. Give him a colorful pencil or a highlighter. Give him the highlighter. I will quote all these things. I'll accept that this is duly taken. We will accept that this is duly taken.
No, just I am appraising this court. Here, one sentence is there. By this is.
See, Mr. Counsel, what I'm saying is, whatever you are arguing, please highlight it so that I can quote in the judgment that these are the materials. According to the prosecution, that these are the materials which amounts to an abatement leading to commission on offense under section 306, and this is an abatement under section 107. This is your argument, isn't it?
Yes.
So to record your argument, I want this, I'll quote those questions, last conversation. So please mark it. Mark it and give it to me.
Yes, sir.
Otherwise, I could have dictated right now, but since all this is to quoted.
It will take time to compare the pagination because there is no.
No. I do not need pagination. I just want to highlight and give it back to me. Are you getting my point?
Yes.
You are reading from a paper. Yes. Now you are relying on some conversation. Please highlight those conversations and give the documents back to me. Isn't it? Then while, because this paper will no more be required for you because we are concluding the hearing. Okay. Not writing, please take a pencil. Itanagar has become so poor. Or what? Your pens are also, you have not, nobody, I have seen yesterday also. Computers were installed, it was not working. We'll hear you, we'll hear you. Just let the public prosecute, because he is the privy to the case diary. Your case is your statement, the conversation, and the FIR. And second case is that investigation should further proceed to take out whether it was an abatement. Now, what evidence? Who will say this is abatement? He is no more. Had it been a suicide note, only person with whom he allegedly talked, the conversation is before us. We accept it to be correct. The person who lodges the FIR, who knows the history and geography of the facts, how their marital discord was there, has been written in detail in the FIR. And statement is also recorded under 161. This is the material, nothing. This is the material.
The solution is if there is no any findings against the person, the police have to have filed an FIR. Because, but at this stage, that cannot be a ground for, then 482 power will go. Since let them do investigation and file final report. If no case is made out, our hands are off. This is the 482. Yes, you highlight it.
My lord, deceased died on 19th October 2019. The FIR was lodged on 22nd June 2021 after 1 year, 8 months. And even though I agree, my lord, let everything that is with the prosecution be taken up. Then also the abatement of suicide does it constitute.
See, therefore we are not going to all this delay in FIR and all. FIR lodged when?
FIR lodged on 22nd June 2021. Accused died on 19th October 2019. 19th October 2019.
There are 2 copies, no? No, forget about the earlier. Okay. Yes, see. Hearing concluded, judgment reserved. What are your judgments? Case diary, I will return you back later, no? We'll see. We'll see what is 107, what is 306, what the Supreme Court says. Okay. What the Supreme Court says, whether within that parameter, within the parameters, whether this material, if the materials available are accepted to be correct, makes out a case, makes out a case under case for
whether the FIR can request at the investigation stage or not.
Yes,
that is the main point.
Oh, there is law is well settled.
Yes.
That can be. Niharika is saying only so far relating to stalling of investigation. Niharika says that investigating authorities should have a right. And in that, we'll rely on the Niharika also. If Niharika itself says, but there is a caveat. This judgment will not take away the power under 482. What Niharika says that investigation should not be stalled. Let the investigation go on, because the FIR is not the encyclopedia. Isn't it? In this case, not only the encyclopedia is available, the statements are available, we are taking it to be correct. We are taking the conversation, last conversation also to be correct. Okay? We are not saying who is wrong, who is right. We'll take the investigation and statements to be accept to be correct. And thereafter, whether it will come under the parameters laid down in this regard. And if it comes within, then we'll say this is not a case of quashing, and it says that no, this is not, cannot be treated as an abatement on the basis of the material available, then we'll say this is, we will quash it. Either way.
My lord, the investigation was never halted. There is
No,
stay
there is
order.
no,
There is
there's
no stay order.
stay, I've seen that. That we cannot presume, number one. Number two is in every cases, there are some witnesses. Suppose in 302, they project a person to be a eyewitness. Okay? Some person to be eyewitness. Their statements are recorded. In a 302 case, very important would be the postmortem report. Whether it is a natural death, whether it is a anything. So suppose immediately witnesses statements were recorded and the postmortem report is there, but investigation is still to be continued. And the eyewitnesses says that no, he fell down from the tree and died. And the postmortem report says that it is a death of falling. What investigation further is required? Here is a case where the family member, the person who died, victim is no more. The family alleges that for this person, he was compelled to commit suicide. This is the main. And this has been alleged by the informant in his affair in detail. We accept that to be correct. His statements is recorded. We accept that to be correct.
No, the informant statement has not been
recorded. 161 is there.
Yes, it's there.
Yes, it is there. It is here. Subsequently, he writes a letter to the IO saying that these are my additional statements.
Additional statement.
Okay, there also we accept to be correct. This can be the best with evidences.
Last recording it states, but no date has been mentioned there.
Anyway, but we'll accept it. We'll accept it. He has written a letter to the IO saying that this is my statement and this is the last talk between whether that will have evidentiary value or not. This is a suppose we today say that okay, prima facie case is made out, therefore we dismiss his case. Now whether that evidence is reliable, trustworthy or not, this is a subject matter of trial. We will not go there. Yes. We will accept this to be correct for the purpose of 480. Then whether is made out. That's all.
Highly obliged.
Today we will not dictate this. Some other works are also there. Hopefully delivery will be on the last date. It will not take much time, but I am preoccupied with some other works.